Hi everyone, Pacchia here. You're watching Between the Lines, part of Fault Lines' look at the many cracks in America's criminal justice system. Today we're talking to Ken Womble. He joins us from his office in Brooklyn. Ken, good to see you. Thanks for joining us.
Good to see you, Lee. Thanks.
So, okay, we're going to talk about a topic today that I really am confused about. I totally don't have the expertise to go into this conversation claiming to know anything about it, but we've published a bunch of articles on Fault Lines in recent days about the so-called trial tax issue. I'm just going to dump this mess in your lap right now and ask you, why are we talking about this? What's trial tax?
So basically, trial tax, Noel Arangeri, one of the writers on Fault Lines, he brought up this concept of a trial tax, and any criminal defense lawyer gets it right off the bat. Trial tax is basically that unknown that if you go to trial and you lose, the possibility that a judge is going to hammer your client with a long-term prison or an enhanced penalty. So if you're basically going through a case and you're dealing in, let's say a robbery case, and you're trying to negotiate the prosecutor down from 5 years to 3. If that doesn't work out, your only other option is to go to trial. If you go to trial and you lose, your client might end up getting 10 or 15. So that's, I think, what he was referring to. Well, that's what he was referring to with the trial tax. And it has a pretty chilling effect.
Is it new? I mean, it sounds just like that's how, courts work. I would imagine this is something that's just as old as, lawyers appearing in front of judges.
Yeah, it's not at all new. In fact, I would think that it probably was worse in olden days, as many things were with the law. But still, look, I've appeared in front of judges who have explicitly stated, even on the record, that if your client goes to trial and he loses, I am going to max him out. But you're absolutely right. It's not that thing in the criminal law that is inherently wrong or really has a wrong feel. I think a lot of people look at it and they say, well, yeah, if you go to trial and you lose, you're going to pay for it. And I think that makes sense. But I think what Noel was trying to point out was that while that may be valid, the effects that it has on specifically plea bargaining, that's where it really becomes problematic.
And Andrew King, new guy at Fault Lines and prosecutor, jumped into the fray with an interesting piece saying it's not really a so-called trial tax, it's a plea discount. Could you summarize his point of view in all this?
Yeah, absolutely. It's fantastic to have a place like Fault Lines and have somebody like Andrew King come aboard to get a prosecutor's perspective, because we can kind of shout in our vacuum all we want, but when somebody comes in, and I think that's what got me to write the article that I did that came out today, was Andrew stepped up and he's, right off the bat, he's new to Fault Lines, and he said, hey, Noel, great article, I disagree with you.
Right, just hit him with a baseball bat, right out of the gate.
He sees it. So Andrew makes a really interesting point. I think that he kind of sees if you go to trial and you lose, the sentence that comes then, that's kind of the baseline. And if you're able to engage in plea bargaining prior to trial, then you kind of get what he kind of terms a plea discount, which is, and we've all used the words plea bargain so much that it's lost meaning. So it's kind of nice that he talked about it in a different way that reminds us that, yeah, plea bargaining, there is a discount in theory and in reality. And going back to the robbery example that I gave, maybe certain people do think that if someone commits a robbery and they go to trial, they lose, they get 10 or 15 years. If they can save the state the trouble and save the victim the trouble of having to come in, there's a lot of factors that go into that, then the defendant, the person who committed this crime, has the potential of getting a discount by taking a 3 or a 5 prior to a trial.
Right. So for people who don't spend every waking minute working in the American criminal justice system, what's the bright line implication of this debate? What does it ultimately mean?
Well, what I saw about this is I thought that, Noel's and Andrew's articles were very good points, but I thought that they missed the bigger problem. In theory, a trial tax, I think, makes sense. For instance, if somebody commits a robbery and it's included in a stack of papers in a file, that's gonna that's going to warrant a different sentence than if the crime is laid bare before the sentencing judge during a 1-week trial. Then, of course, that sentence is going to be enhanced. I think on the other end, the idea that you plea bargain down to have to avoid and try to, allocation of resources for the government, and then also, you're allowing, and again, prosecutors, it's beyond a reasonable doubt. That's the standard of proof. So for a prosecutor, there's not certainty on their side as much as they may seem to play it that way. There's also a benefit for them to not have to go to trial, because if they go to trial, they might lose, and potentially a guilty person walks free. But where the problem really comes in is in the whole plea bargaining process. It's risk assessment. And I think that Noel wrote an article today, kind of in response, kind of that part of one of those articles that you were referring to. And the risk assessment, that's where I take issue. Because to assess risks, you need information. And the problem with the criminal justice procedure, criminal case comes in, there is this long drawn out discovery process where there are police reports, there could be video, there could be 911 calls, there could be any number of pieces of evidence, pieces of information that should guide the defendant's decision of whether or not to take a plea or whether or not to take his case to trial. The problem is 3 months in, defendant doesn't have that information. The state does. But the defendant is still pointed at and said, hey, you have to make a decision. And if you don't make the decision we like, we're offering you 3 years today. You come back on the next court date, it's 5. We're not providing, and we're not providing defendants with the evidence early enough in the process for them to make an informed decision in this very, very important scenario. And oftentimes, it's completely unnecessary. It can take months to get a copy of the police report that is literally sitting in the DA's file at arraignment. There's no purpose for that other than delay is friend of the government.
So what's the fix here?
The fix is
increasing capacity in the system, throwing money at the problem, rule fix? What's the Ken Womble prescription? Speed
up the damn discovery process. It's that simple. Because the fact of the matter is what that sounds like to a lot of people is that it's going to bog up the system. It's going to really, really grind things down. But honestly, as a criminal defense attorney here in New York, I go to court all the time for an adjournment. That's it. Okay? That's however long it takes me to get there, however long I'm sitting in the front row. The DAs, it's the same thing for them. There's so much clogging of the system because we're basically saying, all right, let's put the case over for another 2 months so I can get a copy of those 5 pieces of paper that you have in your hand right there. If we just move everything to the front end, then the decisions can be made that can get these cases out of the system earlier. Because honestly, if there's video of my client and it's clear as day that he is the one with the gun robbing that cash register, then trial is off the table for the most part. And if I have that information at the front end, then I'm going to want to engage the government. I'm going to want to engage the DA so that we can try to get this thing resolved. But if I have to wait 9 months on that, that's what's clogging up the system.
Ken, interesting stuff. Thanks for joining us today, sir.
My pleasure.
That's Ken Womble, contributor at Fault Lines and criminal defense attorney based here in Brooklyn, New York. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can find us at MimesisLaw.com under the Fault Lines tab. If you like today's video, please subscribe to us on YouTube. There's more good stuff coming. If you're listening to us over a podcast, be sure to give us a good review in iTunes. It makes all the difference in the world. There is a link to Andrew, Noel's, and Ken's articles embedded in the text of this YouTube video. I'm Pacchia. Thanks for watching. See you next time. I gotta say, it's a topic that we approach with a little bit of trepidation at Fault Lines because it's not quite in the criminal justice system, at least not yet. Scott Greenfield, don't want to put words in your mouth, but you suspect it's not even going to get there. Why is that?
Unless something comes out that we're completely unaware of at this point, a smoking gun where somebody was told,